update. It was very basic stuff, but we are still there. We still have. Hello. Yes. Apologies, we must start recording from this end as well, so let's see. Okay. Just give me a minute or two.
France, apologies. This is Barbara. All good. You can proceed. We're recording. France, please proceed. We have started recording on our end. Apologies.
Okay. Okay, so today we'll be dealing with a general overview again, as well as a number of questions received from delegates, not just prior to this webinar, but also during the course of the year, that I thought well worth sharing with the rest of us as well. And then tomorrow we'll have a look at the National Credit Amendment Act. Although signed off by President Ramaphosa, it is not operational yet. Last I heard from the National Credit Regulator is that they were thinking of implementing before the end of the year, which obviously is not going to happen. I haven't had a reply to my queries regarding implementation later next year then, but in any case, we'll be dealing with that. And then a number of important decided and pending cases that we have to take note of. Because of the COVID and lockdown situation and situations in the court and so on, we haven't had up to a very late stage, and you'll see that when we do the update on the important cases, we haven't had much by way of case law, and that what we did receive, we received in the past 2 or 3 weeks. And then we'll get back to questions received, and that's where you can also send me questions to my Gmail address. And then tonight some of them I suppose will be easy to answer, and some I'll have to do some research, and some I simply won't be able to answer, but then at least we can share your question with the group as a whole. Okay, so the slides that you will be receiving, you will notice that up to slide 47 is basically an overview of the applicability of the NCA to credit agreements, different types of credit agreements, etc., etc. Now, strictly speaking, this should not be part of an update, but judging from the requests and also from some of the questions that have been asked, we are in the situation, and I dealt with this about 2 years ago, where we had a face-to-face seminar and the delegates, the feedback, one delegate said, it was a good seminar, but a lot of old stuff and basic stuff. We could have done this in an hour or two. And then another delegate attending the very same session said, simply too much new information. It should be held over at least 2 days. So it also depends on your level of expertise, experience, etc. But yeah, judging simply from the questions received, I find it necessary to go back to the basics. Otherwise, the answers to some of those questions will simply not make sense. But it will be, because of time constraints, obviously, we'll go through this very, very quickly. Okay, so the first important thing is you as an attorney must decide, you have this credit agreement or you have this problem in collections or litigation, does the NCA in fact apply to this credit agreement? Now, the general section there, section 4, says that it applies to every credit agreement between parties dealing at arm's length, made within or having an effect in the Republic. And then, of course, there's provision for certain exceptions to that general rule. So, firstly, having an effect in the Republic, no new case law. Sunrock Limited versus Louis is still the only reported case in this regard. And there's also an article that I refer you to by colleague Peterson that you can also read regarding this. Agreements not at arm's length. The Act does not define the concept in the definitions in Section 1 of arm's length. It instead gives us a list of agreements deemed to be not at arm's length, and therefore the Act would not apply to those agreements. The obvious one is the shareholder loan between a juristic person as consumer and a person who has a controlling interest in that juristic person. So normally the majority shareholding, but there is case law that says that it's not limited to majority shareholding. Sometimes people have a right of veto or some other similar power that will also give them effective control of the juristic person. Somebody, please make sure your mics are muted. Hello. Guys, just make sure you're... Okay, I think that's sorted. All right, and then of course the obvious one, and here's one of the things that I came across in the past year. It is not simply not at arm's length or within arm's length if it's family members. The Act is very clear on this. It's not just the fact that it's your brother or sister that you enter into an agreement with. There must be codependency or at least dependency, the one dependent on the other, okay? So it's not the familial relationship as such, but the dependency or codependency that is the test there. And obviously arm's length is not, the concept of arm's length is not limited to National Credit Act. You'll find case law regarding competition, income tax, insolvency, and so on that you can also use in this regard. I have listed a number of cases there. And again, you can see this comes from previous presentations, nothing new that I could find. A number of cases on arm's length and what is not arm's length transactions and so on. In fact, the latest one is Fourie versus Geier, where two very good friends entered into a credit agreement and tried to prove to court that this was in fact because of the nature of their relationship and so on, then not subject to the National Credit Act. was not successful, simply because they did not perhaps literally strive to get the utmost possible advantage, but in all other respects it resembled a normal credit agreement, as if between parties dealing at arm's length. For those of you who want to read more on that, we also have academic scripts or dissertations that I have listed there. Okay. Just a reminder, we're going to speak about juristic persons now, and this I say because one of the questions that I received, I could see that the colleague asking the question has all forgotten about the expanded definition of juristic person for purposes of the National Credit Act. Our traditional juristic person, we used to have this joke that we get two types of persons: natural persons, those created by God, and juristic persons, those created by the lawyers. And that basically was your company and your close corporation. You will see that, or you will remember that juristic person for purposes of the National Credit Act includes entities that were previously, or that is normally not regarded as a juristic person, a partnership, an association, or other body of persons, corporate or unincorporated, and even a trust, as long as there are 3 or more individual trustees, or the trustee itself is a juristic person. And then a stokvel again is excluded. All right. Incidentally, in the Consumer Protection Act, the definition of juristic person is very much the same, except that they don't even have that qualification that there should be 3 or more individual trustees in the case of a juristic person trust. They simply say and or trust. Okay. And then the Act does not apply to credit agreements entered into where the consumer is a juristic person, and that juristic person has an asset value or annual turnover of more than 1 million rand, together with the assets or turnover of all related juristic persons. In other words, where we have the same people controlling, to use the term in the Act, controlling interest in another juristic person. So the moment when you see that you're dealing with a consumer who is a juristic person in the expanded definition, and you make sure that the asset value or annual turnover is more than 1 million rand, and I have a suggestion there where you simply in the credit agreement or in the application for credit, simply have that debtor or consumer state that there is an actual asset value of more than a million rand, or a turnover of more than 1 million, and then you put that as part of your pleadings. The threshold of 1 million has not been changed. It's still 1 million. And then, so this is sort of protection for the individual person, and therefore large juristic persons, such as companies with turnover or asset value of more than 1 million, are excluded. However, even the small juristic person, so this is now a juristic person where the asset value and the turnover is less than 1 million rand, so both less than 1 million, and they enter into a large agreement, then that agreement, that large agreement, is also excluded from the ambit of the Act. So a large agreement, as you'll remember, is either a mortgage or a transaction, credit transaction of 250,000 rand or above. And then just a side note here, this does not include a credit facility or typical credit card or overdraft situation, because a credit facility by definition can only be a small or intermediate agreement, is never a large agreement, although that limit on that credit card or overdraft may exceed 1 million rand. Where your consumer is the state or an organ of state, or where the credit provider is outside the Republic and you have applied on behalf of your consumer to the Minister, the Trade and Industry Minister, for exemption of the agreement. And then, of course, the Act also does not apply to the following instances where the cause of action emanates from a dishonored instrument of payment. Now, I know checks are being phased out, but you know, seeing that the prescription period on a dishonored check is 6 years, we will still have litigation on dishonored checks. Now, if that check was given as part payment or payment for goods or services, then that will not be subject to the National Credit Act and the relevant sections and regulations. Okay, so the Act will now apply to small juristic persons, except where they have entered into large agreements. But even where it does apply, quite a bit of the Act is excluded. And this also from some of the questions that we receive, people tend to forget about the existence of Section 6, which excludes chapters or parts of chapters of the Act from being operational, where we have a juristic person to whom the Act applies, or a juristic person entering into an accredited agreement to which the Act applies. Not all of the Act will apply, and I have listed it there. Yeah, for instance, the maximum interest and fees charged. Obviously, the common law usury rules can still apply, but that is, as you know, very strict. A transaction, in the words of African Dawn Property Finance versus Dream Travel, should resemble a transaction tainted with oppression, extortion, or something akin to fraud. So that's quite a heavy thing for it to qualify. All right, so credit agreements then. Every credit agreement entered into in the Republic or having an effect in the Republic between parties dealing at arm's length. But what is a credit agreement? I think one should start off by saying that wherever we have deferral of payment and a fee, charge, or interest is levied either on the deferred amount or on the agreement itself, then you have a credit agreement. You can't escape that by making provision for prepayment of debt and discount. So in other words, you just phrase your terminology different and you think, now I've escaped the Act. No, there's also specifically provision for prepayment of debt and discount offer. In the case of early payment, still a credit agreement. Okay, the credit agreements regulated in terms of Section 8, credit facility, credit transaction, credit guarantee, or any combination. And then they have, of course, their different forms and subcategories. The credit facility, I think we all know what that entails. I have, for purposes here of, again, put up on the slide the definition of a credit facility. Not having time to discuss that. Credit transactions, various types of credit transactions. Your pawn transaction, the old joke, P-A-W-N, not P-O-R-N. That falls outside the limits of the Credit Act. Pawn transactions, your discount transaction, installment agreements. That's your. Just make sure here, the installment agreement is not, it can be, but it is not necessarily the same as the old hire purchase agreement or like other similar agreements, because there is no compulsory deposit. Obviously, in trade, they often require a deposit, but it's not compulsory that there must be a deposit. And the same with the number of payments. You'll remember previously in hire purchase and installment agreements, there were certain maximum periods for repayment, 48 months or 60 months or so. That is no longer retained here. And they even make provision for, not that I've seen one in practice, but where ownership can pass immediately to the consumer despite it being an installment agreement. Mortgage agreement, that's the one secured by immovable property. Secured loans, very much similar, except that it's now secured by movable property. And then a lease of movable property. And here again, one must just be reminded that the lease of movable property is not the same as a straightforward rental agreement. Because in terms of the definition of lease of movable property in the Act, there must be provision for ownership at the end of the lease passing on to the consumer, either conditionally or unconditionally. So just make a note of that. And then, of course, I think there is a later slide also, just be aware of the fact that we're speaking of movable property. I have received one or two questions regarding leases of immovable property, where people thought that somehow this would also fall within the ambit of the National Credit Act. It does not. I think you have enough problems with ESTA and PI and rental acts. You don't need even more legislation. Mortgage agreement. And then this one is also often the subject of questions, perhaps because attorneys often provide credit, not in the normal sense of the word, but falling within the definition of incidental credit agreements. So this is an agreement, irrespective of its form, in terms of which an account is tendered for goods or for services that has been provided or that will be provided over a period of time. And then we send an account, we render an account, and only if the consumer, or perhaps in our case, the client, fails to pay on due date, on or before due date, do we start charging interest. And then that agreement becomes, it wasn't initially the intention to have a credit agreement. The intention was that they would pay before a certain date. And there was no interest levied from day one of the credit being extended or the services rendered delivered. Yeah, and then we have this situation where he fails to pay, and now we start charging interest. Now, the interest that we charge is either the agreed upon interest in the agreement. Should you fail to pay, then interest will be charged. Or otherwise, if you really want to escape the Act, don't even want to go the way of incidental credit agreement, then you would simply charge your mora interest rate in terms of the prescribed rate of interest Act, which at present is at 7%, which is lower than what you would be able to charge in terms of the Credit Act. And then make sure again that incidental credit agreements, those agreements fitting into this definition, that just be aware of the fact again that Section 5 specifically, very specifically excludes quite a number of sections in the Act dealing with incidental credit agreements. All right, so you don't need those pre-agreement disclosures. You don't have to stick to the form and contents of the agreements as set out in the schedules to the Act. your sections in the Act dealing with unlawful agreements and unlawful provisions are also not applicable. Unlawful in terms of the National Credit Act, of course. You still can't put in unlawful provisions or fraudulent provisions or so on. But reckless credit, that's why you don't have to, if you're involved in incidental credit agreements, you don't have to do a credit check and affordability assessment of your clients. All right, so you can see all of those things are excluded. And then perhaps the general one, this 84F, section 84F, and that's the test where you start off with. If you have a look at the credit agreement or something that resembles a credit agreement, you ask yourself, before you go into all the details, you ask yourself, is this an agreement where there is payment deferred? And are there any charges, fees, or interest payable to the credit provider in respect of the agreement or the amount that has been deferred? Okay, so I think that's the sort of the test. The credit guarantee, this is a borrowed term from Canadian and American law. We would normally refer to these type of agreements as suretyships. And we have a different concept of your normal credit guarantee. But okay, for purposes of the Act, as you can see, there's an undertaking by one consumer to fulfill the obligations of another consumer, should that other consumer fail to honor his payments in terms of a credit facility or a credit transaction. So in other words, a suretyship. And now the important thing, and we've also had again and again questions regarding this. People simply don't want to accept this, where the principal agreement is excluded from the ambit of the Act. So let's say the consumer in the principal agreement is a large juristic person, or it's a small juristic person, but it enters into a large agreement. And let's say this juristic person happens to be a company, and the credit provider demands that the directors of this company signs as sureties. Because the principal agreement is excluded, those guarantees or suretyships will also be excluded. So you will not, as surety, enjoy, even though you're an individual, enjoy the protection of the Act because it's an accessory agreement and the principal agreement is excluded. Yeah, we were referred to this case, Absa Bank versus Louting and others, where the judge tried to distinguish between the situation where somebody simply signs as surety and somebody signs as surety and co-principal debtor. And she, in the judgment, said the term co-principal debtor cannot simply be read as pro non scriptura. But I'm afraid nobody followed that decision. In fact, in the majority of cases, you will see going all the way back to 1978 in the Supreme Court of Appeal, or the Appellate Division as it was then called, lots of case law simply drawing no distinction between whether you're a surety or a surety and co-principal debtor. I think the only difference that I could see was that, except where you've expressly done it, in the first instance, you will still enjoy the benefit of excussion and division. In other words, they first have to excuse the principal debtor before they can look at you as surety. And that is not the case where you are co-principal debtor as well. But in most suretyship agreements, you, in any case, waive the benefits of excussion and division. All right, so we've had as credit agreements, the credit facility and the credit transaction. And of course, the Act to cover all of this and the credit guarantee. Also, because of the creativity of credit providers and people producing financial products to try and cover the type of credit agreement where you structure it in such a way that it doesn't really fall into any of those categories, or perhaps falls within the definition of two or more, and try and escape the acting that way. I think by making provision for a combination, any combination of credit facility, credit transaction, or credit guarantee will still then be your fourth type of credit agreement, your combination agreement, where we enter into a mortgage bond, clearly credit transaction, mortgage, but we also have access to funds from that bond in the meantime, so the so-called access bond, then it becomes a credit facility. It's a combination of mortgage and credit facility, and mortgage will be the main one, but we can't escape the fact that it is still a credit agreement. And then just a reminder again, we've used the word large credit agreement, where a juristic person enters into a large credit agreement. So the categories of credit agreements, as you'll find them in section 9, the small, the intermediate, and the large. So all pawn transactions, irrespective of the amount advanced in terms of the pawn transaction or the value of the goods used as a security or as a pawn, always remains a small agreement. So it's specifically a small agreement. Then credit facilities at 15,000 Rand or below. That's a threshold again, 15,000 or below. That's a small credit agreement. And any other credit transaction except for a mortgage agreement, as you'll see, is always a large agreement. All other credit transactions at or below 15,000 Rand makes it a small agreement, and there is a prescribed form for this type of agreement, contract form, that you'll find in the schedule to the Act. Then your intermediate agreements. This is all credit facilities above 15,000 Rand. So 15 and below, small. Above is then intermediate. And here there is no threshold. So even if it's a credit facility for 10 million, it remains an intermediate one. Okay? Never becomes a large one. We used to make the joke that should your bank manager approach you and say, well, you know, you have a very large overdraft, and you tell him, in terms of the Credit Act, there is no such a thing as a large overdraft. It can either be small or intermediate, so don't stress. Any other credit transaction above 15, but now there's a maximum, 250,000 Rand, except, of course, pawn, always small, and mortgage, always large. And then large, your mortgage and any other credit transaction at 250,000 Rand or above. Okay. All right. I didn't have anything regarding developmental credit agreements or public interest credit agreements. Just a reminder that should your client become involved in developmental credit agreement or public interest credit agreements, and you can have a look at the relevant sections there, he should not only register as a credit provider, but there are two registration forms. You register as a credit provider as well as a developmental credit provider. Okay, so lots of questions in the past regarding the applicability of the NCA to specific types of credit agreements. Acknowledgements of debts, checks, municipal rates, and again this year, some questions on that. Sectional title levies, discounting, open accounts with interest charged, and it's become more relevant now because people are worried if the account that they grant to a consumer, if that of course falls within the ambit of the Act, then they become credit providers for purposes of the Act, and then there's registration and all that goes with that. And by far the most questions that we've received during the course of the year is regarding registration of credit providers. And we'll be dealing with that under the question section. Okay, so the AOD is a credit agreement because it is deferral of payment and there's interest or costs charged. But if the underlying debt is for damages, then it becomes an arrangement to pay, and it's not a credit agreement. So if let's say it's a motor vehicle collision, I suffer damages to my vehicle, I sue you, you approach me, you say, I admit liability, but I can't pay this full amount. Can I make an arrangement to pay? And then I say, yes, you can. And to set off this advantage that you have, that you pay over a period of time, I'm going to charge you legal interest. Then that does not become a credit agreement because our underlying debt was one of damages and not credit. No money changed hands or goods. There's no credit involved here. You can also read those two very excellent articles, one from our colleague Ariana Omar, Old Day Rebus, and then one from Professor Corlea van Heerden, where she also analyzes the position. Checks. I think that you can read through in your own good time. You have the cases there. I don't think I have anything to add to this. Yeah, again, this year somebody asked questions regarding rates and fees. No new case law. Nelson Mandela Bay Metropolitan Municipality versus Nobumba is still the leading case. And this could also perhaps be a test that we apply. Municipal rates and taxes are not levied in terms of the National Credit Act, of course, but in terms of the Municipal Property Rates Act. And you see later when I've received some questions on school fees, there's a similar situation there. So the NCA will not be applicable. Unpaid fees for services, in terms of a service agreement, that could be a credit agreement. And it normally takes the form then of an incidental credit agreement. In other words, the municipality, the local authority, provides on an ongoing basis water and electricity, well, hopefully on an ongoing basis, electricity, and they do that on by way of a credit agreement, isn't it? Because we do not pay as we use, except if it's one of those prepaid systems. We get billed at the end of the month, and then there's a cut-off date that we have to pay. And if we fail to pay, then they start charging interest on the arrears. So that is in a sense then it becomes credit. It becomes an incidental credit agreement. Sectional title levies, again, in terms of the Sectional Titles Act, with its own rules and regulations, not credit agreement. This one we dealt with extensively 3-4 years ago when it was very much, I think there 2016, 5 years ago, very much in the news. This is where our conveyancer or his client provides the so-called bridging finance, often to estate agents, sometimes to sellers of these properties. And then they have an arrangement that on date of registration, when the purchase price becomes available, then the money so advanced, or the bridging, is then paid back. Now, obviously, this is where one has to be very, very, very careful. If you buy the rights at a discount, the rights to this purchase price at a discount, then it is not a credit agreement. You're taking the chance, you're buying the rights at the discount, those rights may never materialize. But if you simply lend the money to this estate agent and you tell him that whether this property registers or not, you borrow the money from me, I'm charging you interest that is payable on date of registration, or at some later date, doesn't matter. Then, of course, it's a money lending transaction and will fall within the ambit of the Act. Good case law on this, where they also have a look at, and also the article of Veldsman in the De Rebus, where they also look at the wording, how to distinguish between selling of rights at a discount and simply a money lending transaction. All right, lots of case law again on open accounts. So I provide credit in the sense that you buy, let's say, a building material from time to time on an open account, and then at some stage I render an account, and if you fail to pay, I'm going to charge you interest or some other form of penalty. All right, so again, it will all depend on the wording of those individual specific agreements or applications for credit. As you will see when you have a look at these cases that we mentioned there, sometimes it's regarded as no credit agreement at all, and sometimes it can be regarded as an incidental credit agreement, and I have given you quite a number of cases in this regard that you can have a look at. All right, then rental agreements. This is normally not regarded as credit because there's simply an amount payable per day or per month or for the duration of the rental agreement, and there's no interest or levy or charge over and above the rental amount. And this is where the article of Stoop and Vittori comes into it. Be careful of so-called rental agreements, which is actually lease agreements. All that they do is they capitalize the interest, and it looks as if it is a straightforward rental agreement. But looking at the amount of the rent and so on, you can see that it is not market related at all. So it becomes a simulated agreement. One must be careful of that. Scania Finance versus Bauer, for instance, made provision in the agreement that there's no interest, it's just a straightforward rental, but should the prime interest rate of a specific bank increase, then the rent will also increase. And that made the judge decide that this is not a rental agreement, that's not part of rent, that you increase the rent every time there's a change in the interest rate. So the interest was most properly just capitalized and made to look as if it's part of rent. Okay, then some other situations that has arisen in the past. Unearned commission, advance against unearned commission. It's not a secured credit agreement. Quite a complex one is that Bryson Commodities versus Pretorius, which decided not a credit agreement. If you have a look at that agreement, it's quite obvious that somebody was taking a chance there. And then This is a slide that I put in again. I thought by now everybody realized that a policy of insurance or credit extended by an insurer solely to maintain the payment of premiums on a policy of insurance is not a credit agreement. So I have a built-in value in this policy, sort of a cash or surrender value, and then that is used to maintain payment of my premiums. Because I have a cash flow problem, I can't keep on with the premiums, and then that goes off against that built-in saving or surrender amount. That does not make it, it is specifically excluded. Transactions between a stokvel and its members, yeah, colleague called me in this regard. It is limited to transactions between a stokvel and its members. Obviously, stokvels can and their members can enter into credit agreements with outsiders, and they do. That's still a credit agreement. It's just those agreements between the stokvel and its members. And then the lease of immovable property. Excluded, specifically excluded. Yeah, and then just in conclusion regarding this part of the seminar, what happens if the parties are under the impression, so it's a common mistake, that the Act is applicable and they structure the credit agreement according to. Well, obviously, you cannot agree that a credit agreement that falls outside the scope of the Act is now within the credit, just as you cannot contract out of the Credit Act if it is applicable. I think that stands to reason. You can, however, include in your agreement that would be outside the National Credit Act certain rights and obligations contained in the NCA can be contractually agreed on. As long, of course, and this is a very basic principle of agreements, you do not impose obligations on parties who are not parties to the agreement, non-parties. For instance, the National Credit Regulator or the Consumer Tribunal, or, you know, that's the remedy. You go to the National Credit Regulator, but it's not a credit agreement, so you can't do that. Okay, I think we've done quite a bit. Would it be an appropriate time now, Barbara or Amu, to give us a few minutes convenience break?
Yes, Mr. Franz, we can break now.
Okay, what with 5 minutes, 10 minutes, what would you normally do?
You can do 10 minutes, it's okay.
10-minute break, okay.
Yes, sir.
It's 11:20 now, so if we can be back by 11:30.
Yes, sir.
Thank you very much.
Thank you, sir.
Remember to mute.
Wat hier dat is kyk.
Julle is nog op unmute, hoor.
Saai. So jy klik net
Right, I think we've had our little break. Let's see how it goes from here. I'm now, again, I appreciate the fact that we have some very experienced practitioners here working with the National Credit Act on a daily basis and so on. And some of the basic stuff must be quite frustrating for you. But like I said, there are also people, let's call them new entrants into this field of law. And we have to cater for them as well. Perhaps, and I'll discuss this with the authorities, perhaps it's a good idea to at some stage have a proper update, just an hour or two update, and then a separate basic course, if you wish, on the whole of the National Credit Act. Okay, so I've received questions. These are not all the questions I've received. We have saved some for tomorrow when we deal with other aspects. Regarding school fees, trust as a juristic person, electronic delivery of section 129 notices, your 129.1a letter of demand or notice of default. And then by far, the most questions regarding registration as credit provider and the duties and obligations of a credit provider and what one should be looking for and so on. This is no doubt as a result of the case that we'll be looking at of Carstens again. And we'll go through them, and then I hope you appreciate why we had to do that very basic introduction as well, or refresher in the case of most of you, I suppose. Okay, so the first question that I want to deal with was one received. Are school fees under the NCA, and if so, is it a discount agreement? Just a reminder, sorry, I forgot to say, just a reminder, we are back, and please see to it that your mics are muted. Otherwise, we might become party to some very privileged information, isn't it? And please, all delegates, see to it that your mic is muted at this stage. Thank you. Okay, so are school fees under the NCA? So I suppose, is the NCA applicable to school fees? And if so, is it a discount agreement? And then a similar question, public school grants parents a discount if all of the school fees are paid on or before a certain date. Am I correct in saying this is an incidental credit and the school is exempt from registering as a credit provider? All right, so school fees. Okay, school fees are levied in terms of Section 39 of the South African Schools Act, and thus falls outside the ambit of the National Credit Act. And you will see, if you have a look at the Schools Act, they have their own provisions regarding the setting of school fees. They make provision for a collection method of school fees. Sections 40 and 41 specifically prescribes the requirements to be met before debt collection can commence. And that requirement is not to send a Section 129 letter in terms of the National Credit Act. For instance, one of the things that I came across, I've never done collections of school fees at all, that all parents had to be informed of the application for exemption of school fees in certain instances, and that a 3-month period must be allowed for payment, either payment or application for exemption. So it's quite a new field to me. And I came across a chapter in the Basic Education Rights Handbook, and I've given you the reference to where you can access it on the internet, where they deal with this extensively. So, short answer, no, the NCA is not applicable, and therefore the question whether it's a discount agreement or an incidental credit agreement becomes not even academic. It's simply not appropriate at all. The next question, the trust as a plaintiff. All right, so we've already said that the trust, unlike the normal situation where it's a sort of a sui generis situation, the trust will not sue and be sued in its own name, but the trustees, in their capacity as trustees, etc., etc. Okay, so the question here was, we instituted action for eviction of an unlawful occupier. And that is already, the moment when I received this, an eviction of an unlawful occupier, I was wondering, why do they send this question to me? Because eviction of an unlawful occupier surely concerns, and arrears rental concerns a lease of immovable property, and then is, in any case, outside the ambit of the Act. The trust has 3 trustees. I suppose the colleague here was aware of the fact that the definition of a trust in Section 1 says that a trust with 3 or more trustees is a juristic person. So he made sure, yeah, there's 3 trustees. At the hearing in terms of Section 4, Sub 1, the magistrate struck the matter from the roll, stating that a trust lacks locus standi. Your comments and advice, please. Now, I suppose what happened there, unfortunately, I couldn't make contact with the person sending this. I suppose that you cited the trust being the either the occupier, or the lessee or the lessor as a trust, you know, the Haupt Family Trust, the trust duly incorporated or something like that. That might be the problem. Okay, so to summarize, agreements of lease of immovable property are specifically excluded in Section 8.2 of the NCA. So if it's excluded, then the definition of a trust with 3 or more trustees becomes irrelevant. So I suggest that you amend your summons by replacing the trust with the individual trustees. And I had a look at the case law in this regard, and I came across, I think the old classic case that I knew about was Rosner versus Lydia Swanepoel Trust, where the sui generis position of trusts are fully discussed. And then I also came across a 2020 Supreme Court of Appeal case, Tusk Construction Support Services versus Independent Development Trust, where the SCA specifically allowed this type of amendment. In other words, I suppose you would have a choice, isn't it? You could either withdraw the action and issue a new summons, now citing the trust correctly, or the trustees then, or otherwise you would be able to amend, and your authority for that was very clearly discussed in this Supreme Court of Appeal case of Tusk Construction Support Services versus Independent Development Trust. Have a look at that, and feel free to contact me again if your magistrate is still of the opinion that this cannot happen in this way. So in effect, I think what the Supreme Court of Appeal said is that we are not changing parties here or substituting parties. We are amending just to render an incorrect description correct. Right, then a colleague, and I've also seen this advert, delivery of Section 129 notice via electronic means. So he says, I've recently seen an advert on the internet of a service provider claiming that electronic service of Section 129 notices were allowed in the High Court in Gauteng. We cannot find any reported case in this regard. Could you please address this during the update? Well, neither could I. What I did find was applications for orders for substituted service, not of a Section 129 notice, by the way, by way of, just a moment, please. Okay, I think you're all aware of the situation regarding substituted service in an alternative way than the normal service by way of sheriff. Yeah, the interesting one, of course, is where Facebook Messenger was allowed to be a method of service, posting I think it was a notice of set down on Facebook Messenger. There is your case law in this regard. But the Constitutional Court judgment in Cebola and another versus Standard Bank and Kubiana versus Standard Bank, that is still the position, the relevant legal position at this stage, as well as the fact that after Kubiana, but before, after Cebola, but before Kubiana, the National Credit Act was also amended with effect from February 2014, which introduced Section 129 sub 5 to 129, where it makes provision for registered mail and or delivery by hand of 129 notices. Now, having a look at the electronic service of Section 129, for instance, in terms of the Electronic Communications and Transactions Act, ECTA, there is provision for electronic service, but if you read through the Act, you will see that it effectively grants a monopoly to the South African Post Office in this regard. And the Post Office has not been able to provide the services foreseen in that Act. And I then also contacted colleague Brett Bentley, I think who's well respected as an expert in collection matters, and also on the Electronic Communications and Transactions Act. And we had lengthy discussions on this. And he said, yeah, people are claiming that they use authority and so on, and it might well be that in a magistrate court or two, electronic service was allowed, but this is not case law as such that you will be able to use. But then he brought to my attention that the South African Post Office, as recently as in July this year, called for tenders from service providers to supply, implement, maintain, and support the secure electronic registered and confidential mail solution that complies with the ECTA Act. So once that tender is granted, and once the, well, I suppose it might have been granted by now, and once the system is up and running and complying with the ECTA Act, in as far as this so-called secure electronic registered and confidential mail solution is concerned, then we might have a situation where, in terms of ECTA, this could be another form of substituted service. So it most probably simply mean that wherever it said it must be sent by registered mail, it can also be sent by way of this online notification or notification by way of secure electronic registered and confidential mail. So watch this space then. Perhaps colleagues who have experience that your local match court or even division allows this form of, as some of those people advertising their services claim, can perhaps also contact me and tell me what is the basis for this and where is this allowed, which divisions or which match courts, and then we can take it up with them. I spoke to a few colleagues in different jurisdictions, and they all held the position that no, we are still relying on delivery by hand or registered mail. All right, and now, and this is going to take quite a bit of time. Because I want to deal with this fully in light of the numerous questions received, and also in light of a lot of cases coming from the National Consumer Tribunal regarding people not registered as credit providers that's supposed to be registered, or registered credit providers not paying their annual fees, or a host of contraventions of the Act, all then under the umbrella of unlawful conduct, and very stiff fines in most cases being given for those transgressions, and also, of course, people being deregistered. And I've also, in a recent conversation with the National Credit Regulators staff members, also become aware of so many credit providers not adhering to the basics of the Act, to such an extent that, just to name one thing, that they've now again had a reason to publish in the popular press a warning that credit providers may not retain credit cards and SASSA cards and ID books of and PIN numbers, of course, of consumers as a sort of a informal, but I suppose very effective debt collection measure. Okay, so first question. In the study material for the lead webinar of 4 and 5 October, so this is fairly recently, it is stated that the courts have finally, in the case of Friend versus Sendel, ruled that a simple AOD is a credit agreement as envisaged in Section 8, provided that the creditor is in the practice of lending and has not entered into an AOD with a debtor on one isolated instance. Okay, I think, of course, that used to be the position. The full bench in Friend versus Sendel, which was a Gauteng division, Pretoria case, ruled one that AOD is a credit agreement because there's deferral of payment and there's a provision for interest or costs or levy or charge, whatever you call it. There's an extra, an over and above. And they also said that be a credit provider means that you must ordinarily be in the business of providing credit, and that in a simple once-off case, this surely could not make you a credit provider. So I think the lead material is correct, but it is outdated. That is what the lead material said. I know they always have a disclaimer in those in the material that said, look, even in the admission exam papers, they say, look, you can study the old papers, but remember the position might have changed from where this was in fact correct. Okay, so Friend versus Sendel, you have the reference there. not in the ordinary course of business, does not make the lender a credit provider and therefore need not be registered. And this was followed by a number of cases, but also there was a number of, there were a number of conflicting cases in this regard. So let me just get hold of, I suppose it's not important now, but yeah, okay. But then one of the cases that followed the full bench decision of Friend versus Sendel was Carsten versus De Bruin, Gauteng Gauteng Provincial Division, Pretoria. But in that case, leave to appeal was granted by the court, and this appeal found its way to the SCA. This is now the position, well, since I suppose September 2018 already. The crisp question asked there was, under what circumstances is a credit provider obliged to register? Now, registration of credit providers has come a long, long way. Remember all the conflicting judgment in this regard and so on. Fact of the matter is, the answer to that question that the Supreme Court of Appeal furnished was where the credit agreement falls within the ambit of the NCA and exceeds the threshold set out in Section 42 of the Act, and I'll get back to that, irrespective of whether it is a single transaction and irrespective of whether the credit provider is a regular participant in the credit industry. And I think this leads to a lot of questions and lots of worries for credit providers or people providing goods or services on credit and for their attorneys, and hence then the numerous questions in this regard that we received. Okay, so fact of the matter is, even if it's one single transaction, a once-off, so to speak, if it is a credit agreement that is entered into, the provider of the credit is a credit provider and should be registered. The court did say that the approach adopted in Friend is pragmatic and makes good sense. But despite that, it couldn't let it stand because it is for the legislature to remedy it, rather than for the courts to attempt to accommodate deficient drafting by attributing a meaning to Section 41B that is not justified in the wording of the statute. Okay, so I think the position is now quite clear. So to get back to your question, yes, the position as set out in that manual or study material or whatever you received was correct, but no longer is. The matter has been turned over. And this happens all the time, especially with a badly drafted piece of legislation like the National Credit Act. We first have to go through litigation and we have conflicting judgment, and then eventually the Supreme Court of Appeal or even in many instances the Constitutional Court has to give us an answer regarding the correct interpretation of this badly drafted piece of legislation, which is good, which is fine for the litigants, but the school fees are quite high if you have to litigate every time that you get stuck with a piece of legislation or interpretation of it. Yeah, and this must be, I tend to be biased. I always think if I get a question like this must be a new generation lawyer that instead of working through the Act or the regulations or the case law, simply wants to copy and paste the checklist from the internet. I know that's not fair, but it is a trend that we see happening. Okay. And then I've had similar questions. I'm not going to list all of them, or I did not list all of them, regarding the requirements to register, the procedure to register, and costs of registration. I suppose, in a sense, then a checklist of all things concerning when and where and why and how and what does it cost to register as a credit provider. Okay, so there are prescribed registration forms, and that you'll find in Schedule 1 to the regulations, or Schedule 1 to the regulations attached to the back of the National Credit Act. There's your Form 2, registration as credit provider. That form speaks for itself. And then the supplementary registration, that's what I referred to earlier when I said in case of your client getting involved in developmental credit or public interest credit, well, it'll most probably be developmental credit. There's also a Form 3 supplementary registration form. And then not all people can, or juristic persons for that matter, can register as credit providers because there are also certain disqualifications in respect of people and juristic persons that bars them from registration as credit provider. So in the case of natural persons, you cannot be registered as a credit provider if you've been removed from an office of trust on account of misconduct relating to fraud or misappropriation of money, whether in the Republic or elsewhere. So if I dip into my client's trust account, or the account held in trust for my client, and I eventually get struck off the roll, I can't say, well, this is a blessing in disguise. Now I can really start making money as a credit provider. Or if you've been a director or a member of a governing body of an entity that has been involuntarily deregistered. And that's why you'll see there's a lot of cases recently where either juristic persons or individuals have been deregistered as credit providers. So they can't just now reapply under a new entity or different circumstances to again be registered as a credit provider. Or if you've been convicted during the previous, or let's say your client has been convicted during the previous 10 years regarding a number of criminal offenses: theft, fraud, forgery, uttering of a forged document, perjury, or an offense under the Prevention and Combating of Corrupt Activities Act, or similar legislation in other jurisdictions, or a crime involving violence against another natural person, or an offense under the NCA or its predecessors. And if you have been, and it's not, okay, so if you've been convicted of any of those that I've just mentioned, and you've also been sentenced to imprisonment without the option of a fine, then, so direct imprisonment, then you will not be able, then you're disqualified from registration as a credit provider. Okay, so that's something to check on as well. Okay, so the procedure in applying, and this I suppose, so you're going to complete or get your client to complete, fill out those registration forms. There must be an auditor, and the auditor's details must be supplied, because later you'll see when there's various things that the registered credit provider has got to comply with, and inter alia there's financial statements from auditors, and also signing of certain documents, that the statistical documents that the National Credit Regulator requires from time to time. All right, then, if you have, and I suppose this is still in the Act and in the regulations, because this was now, of course, for first-time registrants, when the thresholds were amended a number of years, I think 2014 or so. Remember, initially, if you had 100 or less credit agreements, you need not register as a credit provider, or if the outstanding amount under all your credit agreements was less than 500,000 rand, there was no need to register. Those thresholds have been removed, so we're back to square one, even if it's one credit agreement, and irrespective of the amount involved, you have to register. In the case of juristic persons, signed resolutions, of course. Then criminal clearance certificates of all directors, in the case of juristic persons again, payment or individuals. There's an application fee, and then there is also registration fees, which is based on a sliding scale based on the principal debt and is adapted from year to year. So the registration fees, as at 11 May 2016, and they've not been changed. You can see it's a sliding scale. It depends on the total principal amount that you have or that you intend going into, and you can see it's quite a bit of money. I suppose, however, the 330,000 rand registration fee, if you have a book of more than 15 billion rand, is not really serious money. All right, more important perhaps than just the money side of it, the annual registration or renewal of registration, is the formal requirements or compliance with formal requirements once you are registered and conducting business as a credit provider. And again, if you read the cases, or you refer to cases of the National Consumer Tribunal, there is a whole collection of all of the transgressions of all of these. The failure to display a certificate of registration from the premises. The failure to reflect on your correspondence, on your letterhead and so on, that you're a registered credit provider and your registration number with the National Credit Regulator. All right, the failure to pay the annual fees or late payment, and then failure to pay the penalty fees. Quite a number of those as well. A whole series of records that must be kept by credit providers, which they fail to do in many instances. And then quite a number of them not forwarding their quarterly or annual reports. And then one or two cases also where people wanted to deregister as credit providers, but also did not follow the requirements. Apart from those formal requirements, the reporting to the NCR and the like, of course, there are also specific requirements, and that we're not going to go into. That was the subject for many years of these updates. Pre-agreement, even before they enter into an agreement, there are all sorts of mandatory regulations or sections in the Act dealing with marketing of credit, where and how and the content and so on. Then, of course, the fact that every consumer wishing to enter into a credit agreement must be supplied with a quotation and pre-agreement disclosures, which in many instances is basically the agreement that they will be signing, which is presented to them with a quote. Of course, the other thing that we've spent lots of time on in previous seminars, the required affordability assessment to prevent a charge of reckless credit. Right, so where we extend credit to a consumer who will not have the ability to honor his obligations in terms of the agreement. So that you will see if you read those NCT cases, the inspectors of the credit regulator will draw a number of files randomly and then check for the affordability assessment, which is not just limited to, but will include the fact that a copy of the prospective clients or consumers' credit bureau records was obtained. Then, of course, must make sure that there's non-discrimination. The only basic reason to discriminate is the ability to repay, otherwise it becomes reckless credit. But you cannot use other measures. You know, the normal discriminatory things that we find regarding race or language or gender or age and so on, except in as much as it, if it's possible, could have an impact on your ability to repay. I'm now referring to age. Then, of course, a whole list of unlawful agreements, agreements that you're not allowed to enter into, or unlawful provisions in specific agreements that this credit provider and or his attorney must take note of. Prescribed costs of credit. You can't just charge any fee or any interest. And then, yeah, your post-agreement regular accounting to the consumer and all those enforcement procedures, debt collection, in other words, in the case where the consumer fails to honor his obligations. Yeah, and then also, and that we'll have a look at tomorrow as well in more detail, if I remember correctly, the debt review participation. Those consumers who make use of debt counseling and debt review, the requirements of the credit provider to participate in that process. Yeah, regarding the cancellation, no longer just sufficient to give that Form 10 notice of application to deregister, but there's also now required an affidavit setting out the reasons why do you want to deregister, and then proof that you have notified all the consumers, your consumers, credit providers that you deal with, and credit bureaus of your intention to deregister, and that you also returned your registration certificates to the NCR. And then, of course, once you've done that, an affidavit from the auditor confirming that you have in fact ceased business. And the minister may prescribe handover procedure of existing clients or records to a new credit provider, and that new credit provider obviously will also have to be a registered credit provider. and not be disqualified from being a credit provider. Okay, the consequences of non-registration, I think that's also well known. If you enter into a credit agreement where you're not registered, and where you should have been registered, in other words, it is a credit agreement falling within the National Credit Act, the very act of offering or extending credit is prohibited conduct in itself. And the agreement so entered into is an unlawful agreement and void to a very large extent. Okay, so all right, so if this credit agreement is unlawful, and now we're concentrating on the fact that the credit provider was not registered, it amounts to prohibited conduct, as aforesaid, and there may be imposed an administrative fine by the tribunal of whatever is not more than the greater of 10% of the respondent's annual turnover or 1 million rand. And I have seen quite stiff penalties. Obviously, sometimes extremely difficult with these non-registered entities to try and determine their turnover to get to the 10%. So then they fall back on the administrative fine, which can be up to 1 million rand. So it's serious stuff. Okay, so where do we start? We say, first of all, establish the applicability of the National Credit Act to the credit agreements. See if these are credit agreements falling within the ambit of the Act. So if your client only furnishes credit to juristic persons, and these are all large juristic persons, or only enters into large agreements with juristic persons, be they large or small juristic persons, then of course those agreements fall outside the ambit of the Act, and there's no need then to register as a credit provider. Or if the type of credit supplied or the services rendered on credit or the goods supplied on credit are all within the definition of incidental credit agreement. Section 40 excludes registration as credit provider in the case where you only deal with incidental credit agreements. That's why attorneys do not have to register as credit providers, because the very nature of the credit that they furnish is that of incidental credit. However, if you have a so-called investment practice and you start lending out money to clients and charge interest and so on, then of course you become a credit provider. You can't hide behind the fact that you're an attorney. As one of our colleagues at one stage tried to argue at the tribunal, it is not the fact that you're an attorney that exempts you, it is the fact that you only supply incidental credit. Okay, and then you have to inform the client of the consequences of not being registered, the consequences of entering into unlawful agreements, and of the applicable sanctions. All right. And often at those hearings at the tribunal, people will blame their attorney, say, well, no, they didn't tell me about this, they didn't tell me about that. So make sure that they can't level that accusation against you. Okay, so a credit provider, for purposes of the Act, of course, just to summarize, means the party who supplies goods or services under a discount transaction, incidental credit agreement, or an installment agreement. So they're all credit providers. It's just that in the case of the incidental credit agreement, they need not register. If you advance money or credit under a pawn transaction, or extend credit under a credit facility, or if you're the mortgagee under a mortgage agreement, or the lender under a secured loan, or the lessor under a lease of movables, of course, or the party to whom an assurance is made under a credit guarantee. So in other words, you provided credit and somebody signed a suretyship for the due fulfillment of the obligations of the person to whom you've granted the credit. And then the party who advances money or credit to another under any other credit agreement. So in other words, any agreement where there is deferral of payment and there is a provision for interest or charge or levy, save for the so-called open account or incidental credit agreement. And then if you acquire the rights of a credit provider, in other words, some credit agreement or is ceded to you, you acquired the rights of a credit provider, then you've become a credit provider yourself. All right, so I normally with these updates, I also ask of the regulator specific issues that they may have, and I think the one that they mentioned this year, apart from the retaining of credit cards and SASSA cards and PIN numbers and so on, was that credit providers do not provide the necessary credit information to the regulator via the National Loans Register. I'm interrupting myself. The National Loans Register was never formally opened, but there is this SACRA, African Credit and Risk Reporting Association, that you have to deal with in supplying of credit, and the guideline there can be accessed on that website. So apart from the normal reporting of credit to the regulator as well as to the different credit bureaus, of course. Okay, another question. Drafting of acknowledgement of debt. Okay, so this colleague is obviously aware of the fact that the acknowledgement of debt mostly will now be a credit agreement, and that this will require registration as credit provider, and he or she wants to get this credit agreement drafted in such a way that it falls outside the National Credit Act. Okay. Okay, firstly, you cannot contract out of the NCA. You cannot, in that acknowledgement of debt or whatever contract you enter into, so that the parties agree that the National Credit Act will not apply to this agreement. So that you cannot do. But again, and we'll be repeating ourselves now before we have the next break, an AOD might fall outside the ambit, not because of your specific drafting, but remember the basics again. The parties are not dealing at arm's length. So this is a loan that is extended from a father to his son in circumstances where the son is a student and thus dependent on the father, but will be finishing soon and then starting to work, and now I'm buying him a car and I'm extending credit to him, and to get him to know that credit does not come free, and it carries interest, I charge him interest. So at first look, of course, there is deferral of payment and there is interest charged. But seeing that at the stage when we enter into the agreement, he is a family member and he's dependent on me, yes, in those circumstances, it is then outside because the parties are not dealing at arm's length. Just perhaps one remark in this regard that somebody made prior to today's meeting, that concept of parties entering into an agreement where the motive is not the utmost possible advantage. So one must just be careful. I can't recall the case that we dealt with many years ago, but you could also have a situation where I borrow money from you. You do not charge me what the commercial banks would charge me by way of interest rate, but I'm paying you interest at a higher rate than what you would have been able to achieve in a savings account or by utilizing it for your bond. So it's sort of a win-win situation. I pay less for the credit than I would pay to the bank, but you get more than what you would be able to get by way of investing it in a ordinary savings account or similar, or pay off your bond and save interest in that way. And in that case, it was held that that is for the utmost possible advantage of both parties. So it's not just the fact that we look at it from one side and say, well, he's obviously not paying the market-related interest rate. There's also an advantage for him, but there's also an advantage for the other party. So one will be careful with that. All right. Obviously, where your consumer is a juristic person and the turnover and or asset value is more than R1 million, or where it's a juristic person and it enters into a large agreement, i.e. a mortgage bond, or any credit transaction of 250,000 Rand or above. And then in certain instances that we dealt with just when we started, where your underlying cause is not credit, there's no deferral of interest, and charge and costs are not applicable. And then, of course, a word of caution: avoid simulated agreements. You know, if you start asking questions, how can I draft the AOD that it falls outside this ambit of the NCA? Well, obviously, if it's just an acknowledgement of debt and there's no charge or levy or interest charged, then it will be outside the ambit of the Act. But if you start thinking of how can I escape the Act, avoid being guilty of simulated agreements. Those are the agreements where we say there's no interest payable, but then we load. You know, I borrowed 10,000 from you, but then I acknowledge that I've borrowed 15,000, and I'll repay the 15 without any interest being charged. So, not become party to that type of thing. All right, at this stage, I think, let me just make sure from our organizer, as discussed, I went through this basic introduction very quickly. So I could do one or two things now. I would suggest that we have a quick break again. And then I can either start with the stuff that we've actually set aside for tomorrow, perhaps some of the questions that we received there, or otherwise we could have a break now, and then if somebody, Amu, I don't know, if you can just check in the comments section any comments or any questions that were posed there, then you can forward it to me, and we can then have a quick discussion of that. I don't know, what do you suggest? because it is we still have time. I was so afraid that we wouldn't finish in time that I went very quickly through most of it. So what do you suggest?
Hello, Mr. Ha.
Hello.
Okay, I will get the questions that are on the platform, and if anybody else want to also email it to me, that could also be accepted.
Yeah, or on the platform.
Yes, sir.
Okay. And then can we have what would be a reasonable break now? 10 minutes? What do you think?
I
10
think
minutes?
5.
5 minutes? Okay. Then if we can be back at 12 then.
Yes,
Sorry,
sir.
no. Sorry, no. I'm all lost here. It's not. Look, it's 12:26 now. So let's say 12:31, 12:32, thereabouts.
Yes, sir.
Okay.
Okay.
Thank you. So let's have a break then for 5 minutes or so, and then we'll quickly go through any questions received. And then apart from that, we'll see you tomorrow again. But let's quickly deal with those questions that I did not have access to now. Okay, I think I have been able to capture now most of the questions. And those that I failed to deal with now, I'll deal with tomorrow. Amu and colleagues are busy also making notes of them. All right, so let's just see. Albert Marais, I've been in practice for 7 years and still mind-bendingly complicated. Yeah, you're in good company. That's what the Supreme Court of Appeal also said. A mortgage bond to be registered between natural persons and a newly registered trust. Okay, so the trust purposes of the and the amount is sure lots of zeros here. So it's 1.5 million. It looks like it. Yeah. All right. So a trust, if there are 3 or more trustees, or if the trustee itself is a juristic person, is a juristic person then, isn't it? And if the asset value or turnover of that trust is more than $1 million, then it would not be applicable. But this is a newly formed trust. So let's assume there is no assets and not much of a turnover. I don't know what type of trust it is, but let's assume that. The fact is that the amount is above the threshold. It's a large agreement. And the fact that it's a mortgage bond. Remember, a mortgage bond, irrespective of the amount of that bond, is always a large agreement. So even if you say that the trust as consumer, of course, registers a bond of 20,000 Rand in favor of the bank or the person who supplies the credit, that agreement will fall outside of the irrespective of the size of the trust. It's a mortgage agreement. It's a large agreement, so it's outside. Yes, I think so. Oh yeah, somebody asked me. I'll get to that now. The very last slide, I'll give you my Gmail address again. It's hauptfrans@gmail.com. So, Lizanne, if that question of yours regarding the trust has not been fully answered, you want to supply more information, feel free to check the final slide, and you have my email address and you can send me a more email. A monthly subscription agreement where a client pays for monthly services rendered, also a credit agreement? No, I don't think so. Unless if they, no, I can't see. Unless if it's a simulated agreement. But no, this is just a normal subscription service. There's no interest charge or costs involved. So yeah, this is not a credit agreement. Okay, the blue chip case that we'll deal with tomorrow. It is quite frustrating. In that case, just to summarize quickly, the court held that the section 129(1)A notice of default forms part of, it's not precedent to, but it forms part of your cause of action. And that if you want to rely in the match court, as you know, on cause of action to found jurisdiction, then the whole of the cause of the action, or the cause of action wholly, in the words of the Match Court Act, must have originated in the area of jurisdiction of that court. So then both the 129 and all the rest of the things must be within the area of jurisdiction if you want to rely on that. Otherwise, you will have to rely, of course, on the address of the defendant. If you can't rely on the cause of action, then you'll have to rely on the address of the defendant. And then very correctly, Tian says, but that leaves now a gap. What if he keeps on moving? I know I've had the same problem many years ago with Section 65 proceedings, where the Section 65 debtors court, that financial inquiry, would also could only be held where the debtor resides or is employed. And then those debtors would keep on moving, so you could never get hold of them. Yeah, I don't know the answer if he keeps on moving. I suppose you'll have more cases like that, but yeah, I can go into the arguing in the blue chip case tomorrow if you want to, but you know that it forms part of the cause of action, the 129. That's basically what they held. Geraldine asking if we can make the slides available prior to tomorrow's session. It makes it easier to follow. That is something that it's beyond my jurisdiction. We'll have to ask the organizers about that. Okay, if an agreement is concluded.
Sorry, Mr.
Yes.
Jump through. I'll try on my level best to do that for our delegates. I'll try to.
I'll be sending them the revised ones. I'll be sending to you then this afternoon, and perhaps you can send it tomorrow morning. That they just have it. Okay, that's fine then. Thank you very much, Amon.
Yeah, we ask that they become patient because it's some delegates that have registered late, so we try to accommodate everybody, but I will try my level best to send it today.
Okay, thank you. Okay. Otherwise, just send it to Geraldine. She was the only one moaning or complaining. Okay, that's how it works here. You know?
Okay.
Okay. Okay. If an agreement is concluded between a father and son, where the son is not dependent, is it not at arm's length? No. The mere fact that you're family members does not make it not applicable. There must be some form of dependency or codependency. So let's take the question. I think there is a case in this regard also. I think it's Lowe versus Lowe, if I remember correctly. It could also be another surname. Two brothers, blood brothers, enter into an agreement, a credit agreement. But the one is not dependent on the other one. They are both business people in their own right. Then, of course, the act will apply because there's no dependency or codependency. The same here where the son is not dependent. He's a businessman, his dad is a businessman, and they enter into an agreement, the act will apply. This one, Lawrence, can interest be charged for the day that the loan was disbursed? Okay, so do I have it correct? So I extend the money today, and I start charging interest from today. The short question is I don't know. The short answer to the question is I don't know. I'll have to check on that. Perhaps one of the colleagues can help here. I have access to the money from today, so I suppose they can charge from today then. If that is the type of agreement, you know, that from day one we'll pay interest. So it's like a credit facility, for instance. But that one I'll have to check on. Okay, you have there where I'm now. You can see amu@lssalead.org.za or Ntombi, ntombi@lssalead.org.za. You can also send questions to them if you don't want to send it to me directly. Okay. Carol, if the loan agreement is interest-free, does the NCA therefore not apply? Yeah, of course not. On what basis would it apply? Because there must be deferral of payment that we have, but there must also be interest or charge or costs, either regarding the deferred amount or the agreement itself. Latest, this one I also, Charles Hill. Latest tendency appears to be that some attorneys who does collections for their clients sell their book to collection agencies after court order or voluntary arrangement, which agency then raises fees and even higher interest rates. What is this? I don't know. I don't think I follow the Okay, so we sell the book to a collection agency after the court order. Okay, so nothing wrong with that, or voluntary arrangement, right? But then the agency raises fees and even higher interest rates. Now, I can't see how you can increase the agreed upon or the mora if there was no agreed upon interest rate. The interest rate that you received a judgment for, or that you agreed upon, for that matter. You know, I mean, the Prescribed Rate of Interest Act, even it's now presently at 7%. If I obtain judgment for 7% now, even if that rate is raised, let's say in 3 months' time, when the repurchase rate of the Reserve Bank is bound to go up to 7.5%, I can't now amend or change the interest rate. I'm stuck with the 7% that I got the judgment for. So the mora rate at that stage. And even if it becomes 20%, I'm stuck with 7. Likewise, if I get judgment for 7 and 7% interest, and I end up in a situation where the mora interest rate is down to 3%, I can still collect on 7%. I can't unilaterally change that. And the fees, I suppose, tomorrow we deal with the very important case of University of Stellenbosch Legal Aid Clinic versus National Credit Regulator and others. That was recently, a week, 10 days ago, that very important case regarding costs of credit and attorney's costs specifically, and after judgment costs that I deal with tomorrow. And good news for attorneys, not such good news for consumers. Okay, somebody asked me electronic service via email of NCA notices such as Section 129, will that be considered valid service in court? That's what I'm asking you. I say no. I say the Act in 129 sub 5 makes provision for service by way of registered mail, and you have to allege not only that you've complied with 129 sub 5, but you also have to attach your registered slip and your track and trace report and all of those things, at least in the courts where what I know of. Yeah, the other alternative is service by hand, and that's interesting on an adult person, unlike service by way of sheriff, which can be on somebody apparently in charge of the premises over the age of 16. Here it must be an adult person, so 18 or above. And that's the only two ways. So until such time as, in terms of the Electronic Communications Act, and in light of the tender that was most probably already awarded, they comply with the Act, then as far as I know, not at all possible. But I have asked colleagues that if you, or your magistrates or your division is of a different opinion, please let me know. I spoke to 2 or 3 colleagues in this regard, and they said no, no such a thing. Yeah, but tomorrow we can perhaps get feedback on that. Oh, Manana, I think you'll have to send me an email, then I can elaborate on reckless lending and so on. I don't think we're going to have time, not today and also not tomorrow. You know, that is the topic of for the whole day, reckless lending and all the cases in this regard. Okay, once off loan and the utmost advantage. Okay, once off loan is of course allowed. Nothing prevents you from entering into once off loans, and it's in both parties have an advantage. And yes, if there is interest or charge, which is economically sort of makes sense, then yeah, then we can say that it is within the ambit of the NCA. I would think an example of a loan where there is a charge, but we say that the parties are dependent, or there's interdependency, and they're not trying to obtain the utmost possible advantage, would perhaps be something like where I say, okay, you just pay my bank costs. But it's interest free. You see, and there's dependency or codependency. Then I think really that should be able to get within the ambit of outside the ambit of the NCA. Okay, I think I've dealt with all of the questions now. Okay, there you have my email address. So please feel free to send me an email. Even if we do not get to it tomorrow, we might at some later stage. And the only two provisos I have, please don't expect of me to supply you with a legal opinion. I can do that, but then I charge you money, obviously. That's the one. The other thing is, so yeah, short questions, short answers, perhaps referring to case law and so on, that I'll do. That's the one thing. And the other thing is, yeah, I think one must, you must just know that without telling people who the questioner is, unlike that we had to do now, when it's obviously open to everybody, I reserve the right to use that question in a future presentation and the answer as an example of what colleagues are struggling about. So so perhaps then phrase it in such a way that we cannot see the identity of your client, for instance, from it. Because of attorney and client privilege and confidentiality and things like that. Okay, I think we've done well. There's another 9 minutes to go. So thank you very much for attending. Please feel free to send those emails, and then we see you tomorrow morning again. Amu, are we starting again at 10:30? Barbara? Oh, well. Okay, I think that's it then. Okay, there you have an announcement, e-leader platform. Carol, you have my email address now, hauptfrans@gmail.com. Okay. Thank you very much and goodbye.